It is 15 hours 28 in Guyana and right across the Eastern Caribbean. Good afternoon to you wherever you're joining us from. We are coming to you live from 24 Saffron Street, Charlestown, Georgetown, 99.1 FM in Demerara and SC Quibo, 99.5 FM in Berbice, online at KaichuNewsOnline.com via our Facebook page, Kaichu Radio, and of course on YouTube, Kaichu Radio Africa Access. We encourage you to download the MyTuner app or the Radio Garden app and simply select Kaichu Radio. You'll have just heard the ruling from the Court of Appeal in Georgetown, Guyana, and I now hand things over to senior journalist Leonard Gildarie and Dr. Yog Mahadeo, and of course joining us at this time also is attorney at law Mr. Kamal Ramkarran. Gentlemen, a pleasant good afternoon to you. I now hand things over to you.
Thank you very much. Good afternoon all across this beautiful nation wherever you're joining us from. It is June the 22nd, 2020, and let me bring you up to speed what has happened. The court by majority decision today has allowed certain things, which has allowed a motion to carry through to determine valid votes. So there is a stay ordered by the court, and let me, in a very short while, we have two very good gentlemen who's going to bring you the interpretation of what the court has said and what has transpired in the court today. I have with us a good day to you, Dr. Yog Mahadeo. How are you doing, my brother? It is June the 22nd, 2020, and let me bring you up to speed. So, I'm joined, I'm waiting for Dr. Yog Mahadeo to connect with me. I'm hearing a feedback here. Yes. Yog, you there? You hearing us? Our apologies. We're trying to make contact with everybody here, including attorney at law Kamal Ramkarran. Yog, are you with us at the moment? You hearing us? In the meantime, we are going to bring you a couple of things. The court met this afternoon to make a ruling on that case that would have transpired over the weekend at the Court of Appeal there in Kingston. Today, three judges, that is Justice Rishi Prasad, Justice Bassington Reynolds, and Justice Don Gregory Barnes, would have made the ruling. And so, Yog, are you with us at the moment? Are you hearing us?
Yes, I can hear you now. Wasn't hearing you just now.
Thank you very much. Thank you very much, dear. So, in the meantime, while we're waiting on attorney at law Kamal Ramkarran, who would have been one of the lawyers involved with this case, we want to. I want to pass it over to you right away. All Guyanans are at the edge of the seat right now, waiting to understand what would have happened. It was very clear from Justice Rishi Prasad where you would stand. The court has no jurisdiction. Then it came to about half an hour, a little more than that, from Bassington Reynolds, and then Don Gregory Barnes. Yog, for your understanding so far until we have Kamal Ramkarran, could right away, all Guyanans are at the edge of the seat right now, waiting for our apologies, some issues technical there. So over to you, Yog. I give it to you.
Yes, thank you, Leonard. Well, at the end of the reading, at the end of the final decision, I think the rains have descended upon us. Lots and lots of heavy storms up here at the East Coast. Symptomatic maybe of the decision, but indeed, I think a lot of persons would say they didn't expect better. That this was the same court that Rule 34 was a majority of 65 instead of 33, and so they expected this. For me, I know Mr. Ramkarran will be joining us in a couple of minutes, but I found it strange that the Court of Appeal would all of a sudden decide to split one article into two separate, totally separate pieces. So say, on one hand, there is the qualification of the president, and it must be viewed very, very separately from the other part of the same article that deals with the votes cast, total votes cast. For me and from a layman's perspective, I think we are all concerned that this has happened. But, you have to take it in stride, because one of the things that I think has also happened is that the court has not granted any injunctive relief to the applicant. And so we are going to get some translation of what those things mean from Mr. Ramkarran, I'm sure. But one can look at this decision from both perspectives. The applicant has clearly won the court's favor in terms of the court has a jurisdiction. But what does it mean? And Kamal, welcome to you. at short notice again, I must say, Leonard and viewers and listeners, Mr. Ramkarran has been a good friend to the people of Guyana because we have called on him at short notice, and he has never said no. He has never said no. He's always willing to give his opinion as to what happened. And so, Mr. Ramkarran, over to you, sir.
Thank you very much.
Thanks for having me, Yog and Gregory. Thanks. I'm glad to be here again, even though it's short notice. And I had to listen very carefully to the decision so that I could come and tell you what I think about it. What does it mean? One judge, Rishi Prasad, found that the court had no jurisdiction. He dismissed the notice of motion for want of jurisdiction. He said he went through whether or not the court had jurisdiction. He found that Parliament intended that rules were to be made by this court in order to operationalize it. So if Parliament wanted to say how this jurisdiction was to be used, Parliament would have made rules because the Constitution says Parliament should make rules, and no rules have ever been made. He said some important issues that these rules would address were who could bring such a claim, what time they would have to bring that kind of claim, and what time limit there would be. But those rules were never made. He also said that where the Constitution at Article 177.4 referred to interpretation of the Constitution, that it must mean interpretation of the qualifications of the President, and not just a general interpretation of the Constitution and the words of the Constitution. And he said where the Constitution referred to the validity of elections of the President, no President has been elected, so the case was premature. Articles 177.2 and 6 have not yet been completed. So any challenge to the validity of elections once complete must be taken to the High Court. Justice of Appeal Don Gregory and High Court Justice Brassington Reynolds, who is sitting in the Court of Appeal as an additional judge, did not agree with Justice Prasad, and their decision is what is the majority of the court. Their decision is what stands. So Justice Prasad's decision is a dissenting decision. Both of those judges determined that for the 6th day of 2020, which is what is known as the GCOM order, that set out all of the terms of the recount, or the 6th day changed the election regime by adding new things. Well, Justice Reynolds specifically made that ruling that there is a new regime created by Order 6th. He said that Article 177.4 was unique in the context of the Commonwealth, that Guyana was the only country with such a provision. And he said that it did two things. It allowed you to challenge the qualifications of the person elected as president, whether that person fit the qualifications specified in the Constitution or not, and it allowed you to interpret the Constitution. So there were two separate jurisdictions, qualifications and interpretation. The interpretation was not limited to qualifications, but the interpretation of the Constitution is completely separate and distinct. He said that the election petition law spoke to election of members of the National Assembly, and not the election of president, which is what is referred in Article 177 of the Constitution. So he believed that this was a completely separate jurisdiction. Only the Court of Appeal had the jurisdiction to deal with the election of a president. He said that this meant that it didn't conflict with the election petition law, which dealt with challenging elections of members of the National Assembly. He said, since it dealt with interpretation of the Constitution, the court had the power to interpret the words "more votes cast" in Article 177 of the Constitution, and he also said that that is a question which could not be raised in any other court. He said the use of the words in the GCOM order determining a credible final count was not just surplus. Those were not just extra words. He said that it must have been intended that the words would be given effect, and he therefore found that the Elections Commission had the authority to determine the final credible count, and that it must do a qualitative and quantitative assessment, which means your quantitative is numbers, qualitative is the quality of those numbers. His order was that the words "more votes cast" in Article 177 2b of the Constitution has to be interpreted as more valid votes cast within the meaning of Order 60 of 2020. That is GCOM order. Justice of Appeal Gregory largely agreed with Justice Reynolds. He went into great detail on the submissions of the various counts before the court. Justice of Appeal Gregory did not do so. She came to the same order as he did, that the interpretation of more votes cast means more valid votes cast in terms of Order 60 of 2020. The key difference between the decisions of Justice Gregory and Justice Reynolds is that Justice Gregory found that she had no jurisdiction to determine whether the chief election officer's report was valid or not. Justice of Appeal Reynolds didn't make any finding on that, whether it was valid or not, or whether he could find it valid or not. When the case ended, Justice of Appeal Gregory ruled that all parties must bear their own costs. The court was not ordering any costs. Usually costs are awarded to the person who wins the case. And Cashier Khan, who appeared for TCI and Change Guyana, I believe, he asked for a stay of the decision for 3 days, stay of the order for 3 days. And after some conferral between counsel, Justice of Appeal Gregory said that the court was minded to grant that stay for 3 days. So that is a quick summary of what happened in the case.
What's the implication? Let's start bottom up, Kamal. What's the implication of granting that stay for 3 days?
It seemed to have a connection.
Sorry, you're breaking up. Sorry, we didn't hear that last piece.
That means that the connection seems to be very unstable.
Yes, the connection.
Do you want us to call you on your actual phone, sir?
What I can do is I can try using the phone with data to see if that will make a difference. So I'll leave and come back.
Thank you very much. So we take a short break. Do we take a short break and come on back?
Well, in the meantime, we can recap, Leonard. So
Yes.
just to remind everyone that the court would have concluded its deliberations, having worked over the weekend, basically, to give a decision today. And Justice Reynolds, what's the name there, Leonard? Brassington
Reynolds, yes.
And Justice Don Gregory Barnes, two of them would have voted that the applicant does have jurisdiction. The court does have jurisdiction to listen to the applicant's pleadings. And Justice Prasad, in some very short words and in quick order, he basically said there is no jurisdiction and he so ruled. So a couple of things that we got to ask Mr. Ramkarran, of course, is, there has been a stay in the order, a stay of 3 days, and so we want to know what's the implication of that stay. And also, we want to know what's the implication of the fact that no injunctions were specifically granted. What does it mean to GCOM, and where does it leave everyone? And meanwhile, he's coming on back, viewers and listeners, between Mr. Gildarie and yours truly, we're working hard to ensure that we have a very incisive discussion tonight in room 5922. So we're working to put those things together to see how we can get this thing really, really dealt with, because everybody wants to know. Bottom line is what's next. Kamal, I hope this connection is better. Can you hear us?
Yes, I can hear you. I'm on my cell phone.
actually, rather than the
Imagine the
computer.
data is a little better than the normal line. So if you now join us, elections, COVID-19 watch, we bring you updates as to what a synopsis of what would have really transpired at the Court of Appeal today, in which there's a majority decision, and what does it really mean? What's the way forward? We have with us here Councillor Kamal Ramkarran, and he would have been one of the or the representatives of the parties in court. So welcome back,
No,
Councillor.
no, Gregory. I actually heard you say that before. I was not part of this case at
Oh, my
all.
apologies. I don't know where you got that from.
Another Ramkarran who's related to me was part of the case, but not me.
Yog told me that, so I could probably blame him on
No,
that.
no, 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 no matter with him, Kamal.
There was a different Ramkarran. So.
Yes,
You know,
let's.
I suspected that reporters make news sometimes, but I didn't realize this.
Oh my goodness, my,
kidding.
my dear
There's
friend,
more than
my
one
dear friend
Ramkarran
is having
practicing
some
on here.
leftover from yesterday,
Yeah.
but it's all
So,
right.
Kamal, I want to get down
Yes.
to it in terms of what does the delay in what does that 3 days mean to this case and to whatever orders were made?
It means that the order does not take effect. That there is no order until 3 days have passed. So it is as if the Court of Appeal were to give its decision 3 days from today. The order does not take effect until that time passes.
Mm-hmm.
What is the reason that it would ask for 3 days? Is it that there's going to be likely an appeal to the Caribbean Court of Justice?
Generally, when a party applies for stay of execution, they mean that they are going to appeal and they're going to ask that other court to stay the decision so that nothing will happen until the other court is ruled. That's generally what stay means.
So, which brings up the question here, Yog and Council, is the effect of what would have happened here, because the Guyanese people are a little confused, including even some of our staffers. They're saying, what does it really mean? There is a decision, or there are some orders from the chairman of the Guyana Elections Commission to the chief elections officer. What happens now? Could they go ahead and do anything, or are they in a state of holding right now too?
Well, as I said, there was no injunction, so there was nothing preventing them from doing what they wanted to do in the first place, doing what the law required to be done. And right now, there is nothing preventing them. Of course, we know what the order of court is, and we know that it will come into effect in 3 days. But what does that order of court really mean? That more votes means more valid votes. Isn't that what more votes always means?
Correct.
And don't we know what valid votes are and rejected votes are? A valid vote is a vote that, these votes have been counted twice. Once at the place of poll, and the second time at the recount, and the numbers were the same in both places with minor differences. And in each instance, they had to determine for every single ballot whether it was stamped with the 6-digit stamp, whether it was marked only for one list of candidates, because if it's marked for more than one list of candidates, it's rejected. Whether you could identify the voter from what he wrote on the ballot paper, in which case you would reject it, or whether it was not marked for any list of candidates at all. So we know what a valid vote is, and we are to assume that valid votes mean that more votes cast means more valid votes cast. It could never mean more invalid votes cast. So when Justice Reynolds indicated that GCOM had to determine the credibility of those votes in a qualitative and quantitative manner, I don't know particularly what that means. What are they going to do? Are they going to call the people in and determine whether the evidence is true or not true? I'm not sure precisely what that means, or how practically we will determine, other than what the law says about valid vote, which I believe has been done, how we will determine additional validity. Is it that the report the report that has been required on the basis of the recount, is it that is perfectly fine, since the Justice of Appeal Gregory said that she did not have the jurisdiction to determine whether or not his report was valid? I don't know.
Correct. Yeah, it's strange that they would, and a lot of people are interpreting this to mean just more delays, because the court giving itself jurisdiction to listen to this matter does not mean, correct me if I'm wrong, but it does not mean that the applicant will win this case or will lose this case. You just don't know. They will now listen to the case. Am I right, counsel?
No, the case is at an end. The case is finished.
Okay.
The court has found, it has jurisdiction to interpret the Constitution generally, because the contention was that the court could only, if it could at all do anything, all it could do is determine whether or not a person was qualified to be president under Article 90, those qualifications about citizenship and residence and so on. If it could do anything at all, because the contention from Mr. Mendez, senior counsel, was in the court, and the other lawyers, was that the court could do nothing at all. They could not hear the case, could not entertain any aspect of it. So the court has found, first, yes, it can entertain the case, and secondly, that it can interpret what the more votes cast mean, which is what the applicant asked it to do, to determine what it meant by more votes cast, and to determine that it meant more valid votes.
Correct.
So that's where the case is now finished.
Okay, gotcha.
Because the court did both things at the same time. It
Gotcha.
assumed jurisdiction, and it decided the issue, which came afterwards.
Right, gotcha. So Leonard, what this means to us in terms of, I'm sure counsel is going to correct us, but just to ensure that from a layman perspective we get this right, the court would have found that it had jurisdiction, and in finding that it has jurisdiction, would have determined that the interpretation of more votes cast allow them to look into the order, which means or translates to more valid votes cast. Now, Mr. Ramkarran is also very clear in his opinion here that it's a matter of being pedantic. What does valid now mean? And it goes right back to the chairman, does it, Kamal? Well, to the commission.
Or to the chief election officer in doing his report. Is he to determine what it means, what more valid votes mean?
Right.
In presenting his report, because I recall, I'm looking for it in my notes, what Justice Reynolds said. He spoke about what the order said, what the words in the order were that were not surplus, determining a credible final count. That's what the order spoke about, according to Justice Reynolds, determining a final credible count. So more valid votes. Both judges were very specific in saying that more valid votes meant more valid votes in terms of the recount order. They tied it to the recount order. So I suppose the words determining a credible final count has something to do with that.
So my question is, counsel, and maybe over to you, Yog, is what now, as far as GCOM is concerned, what would you say would be their move at the moment?
Is that a question for me or for you?
Both of y'all, whoever can answer. I think Guyana is asking, what can GCOM do at the moment?
It's for you, counsel. It has to be for you.
We go back to the situation where two things are left outstanding. One is the advice of the chief elections officer, and the other is the declaration of the chairman. Now, the chairman must make her declaration based on the advice only of the chief elections officer. The chief elections officer has to submit a report to the commission containing his advice, and then the chairman must make a declaration based on that advice. Based on the advice of the chief elections officer. But do recall that the commission always has the supervisory powers over every member of the secretariat, including the chief election officer. So if he submits a report and the chairman, which he has already done, the chairman had said, look, what I want you to do is to submit your report based on the recount numbers. That's what I want you to do. So that is where we are. Does he now submit a different report? Does he submit the same report that he submitted before, giving the APNU AFC coalition a two-thirds majority in parliament, having rejected 100,000 or more votes?
Right.
And are they then bound to accept that report and give APNU AFC, two-thirds majority in parliament, and just ignore the fact that the recount has happened and the fact that CARICOM, who has been asked to scrutinize that recount, CARICOM has said that the recount is valid and should be used to make a declaration. Your guess is as good as mine.
So it may very well be in the court of the GCOM chair to decide on a way forward within the next 3 days, or
Well,
I'm not sure. It's a
before I ask, before we ask Kamal to comment on that, I just want to place this for Kamal's introspection as well. Look, the chairman has already made certain statements. She can't pull those back, and nothing that the court said, I believe, has any effect upon what the chairman said. Because Kamal is saying now the word the valid is a question, and the truth is these ballots have been counted twice. They have counted at the day place of poll and during the recount. So I think also, Kamal, for your thoughts and comment is, what can the people of Guyana think might be the possible next steps? Yes, we know that the CEO can now deliver his fine, but does it go back to square one? In other words, my point is, does the chairman have to now re-instruct or reconvene a meeting? Does the chairman now have to re-instruct the CEO to give the commission a report on the 24 and 48 hours? Because it is presumed that if the CEO tells some of the commission what his report is going to be, some may not turn up to the meeting, which is going to delay by 24 hours.
Well, another option is that the respondents, some of the respondents, can go to the Caribbean Court of Justice to say, look, a decision has been made by the Court of Appeal, but the Court of Appeal has no jurisdiction to make any such decision. So although the Constitution says there is no appeal from this decision, that applies only to decisions which are made with jurisdiction. It's a complicated argument. It is a legal argument as well, that where a tribunal makes a decision that had no jurisdiction to make that decision.
Right.
The decision is a nullity. The decision is not a decision. And therefore, when it says that you can't appeal from that decision, it doesn't apply to nullities. It only applies to decisions which are made with jurisdiction. You understand? It's a little complicated, but you understand. So what they would say is, look, the Court of Appeal had four corners within which they could act. They went outside of those four corners and did something else. Because they could only act within those four corners, when they went outside, the decision that they gave was not a decision that we can call a decision, because it was outside of those four corners. And because it was outside of those four corners, when they said you couldn't appeal a decision of like this, it means that you couldn't appeal a decision like this, which was made within the four corners, not a decision which was made outside. And this decision was made outside, and therefore we can appeal. Slightly complicated, but that's possible. There is also another view put forward by Christopher Ram in today's Sabbath News, that notwithstanding what I referred to the section as saying as there's no appeal from this decision, that there is an appeal in fact from the decision. It doesn't mean so at all. So either way, it would take them to the CCJ, who would then determine whether it had jurisdiction to hear the case, and then determine what it should do, whether the Court of Appeal had jurisdiction or not.
Correct.
So, and of course, there is this stay of 3 days. So this valid votes interpretation does not apply until 3 days have passed. And that time starts to count from tomorrow, not from today.
Okay.
So tomorrow is the first day, the next day, and the third day. Tuesday, Wednesday, Thursday. So the decision comes into effect on Friday.
So to that point, then it means, given Madam Chairman's reluctance to do anything when it is still in the remit of the court, it means more than likely GCOM is not going to do anything until the third day would have passed.
That is a possibility. I can't speculate around. Anything that is inconsistent with the Constitution is void as in accordance with the inconsistency. So it is not that the Constitution is not that the order can affect the Constitution. It is that the Constitution affects the order. And if the Constitution says something, the order says something different, it is the Constitution which prevails, not the order.
Right.
And that is based on Article 8 of the Constitution, which says that this Constitution is the supreme law of the country, and anything inconsistent with it is void as to the extent of the inconsistency.
Okay. So my thinking is not absolutely flawed in terms of the Constitution being infected now by an order, and it should not have been that way. I know you'll regard it in what you were saying, Council. So, Leonard, now, Leonard, the position is that GCOM may not, more than likely, given the way we have seen GCOM act in the past, they may not do anything within these 3 days. So we have changed from elections watch to recount watch to decision watch to now court watch, and now we're going to move to 3 days stay of execution watch.
We're gonna say we call ourselves the watchmen by the time we finish with this.
Well,
I don't know. I
the
can't.
entire country has been placed into a ridiculous situation. And I just want to appeal to, I believe the person's name is Leslie. I'm not sure if it's James or anything. Please, sir, there's no need for us to become emotional. We can be emotional, but keep our emotions in check. Yes, you have a right to be angry, but, let's be good about it. The court has its say, and tomorrow will be another day. So we cannot allow our emotions control our actions. We got to keep ourselves in check and let us wait. If you are politically motivated, then wait upon the guidance of your political leaders, and I'm sure they will guide you as to what's the next step. Here, we just want to ask everybody and urge everybody to remain calm and to ensure that good sense prevail. It is a majority decision of the court. And you know what? There's a 3-day stay, and all eyes will now go right back to the commission itself. So, Kamal, thank you so very much for that. Any other thoughts and comments from you, sir?
Well, in response to what the Court of Appeal didn't have to grant a stay. The Court of Appeal could say this takes effect from the minute we deliver this judgment. There's no need to grant a stay. And of course, they know when you ask for a stay what it is you plan to do. So, many judges can sometimes be offended if you tell them, I'm going to appeal, which is basically what Mr. Khan was saying when he asked for the stay. They were not obliged to grant the stay, but they have done so, of course, in the interest of the country. In the event that they are mistaken in their views, they know that they're not the final court. They understand that they may be mistaken in their views. They may not have interpreted in the way a different court might have interpreted, which means that they might not be mistaken, but there's a higher court, and a higher court might interpret it differently. And so, while they were not obliged to grant that stay, they granted it. And the gentleman who is becoming emotional, I'm not sure why he's becoming emotional. If he doesn't agree with the majority decision of the court, he should take that into consideration.
Correct. Well said. Well said. That is true. We need to take all angles into consideration. Leonard, any more questions for our learning council?
No, I thank you as normal, Kaito Radio team here, and of course Dr. Yog Mahadeo and everybody. We thank you, Council, for turning up at such short notice to lend some explanation to what is a very technical legal field for a lot of people. And
Well, thanks for having me. The fact that you asked me to come here means that I had to pay very close attention to the decision, sit and listen to it carefully, and write notes, which I would not otherwise have done. I would just have waited for the final verdict to read it somewhere, determine what it means.
Well, it's good because we certainly will be looking forward to having you here again as we continue to assess and analyze what's been happening. But Kamal, I must say on behalf of all of our viewers and listeners, thank you so much. It's really been a pleasure to have you here, especially giving me your very mature ear and your non-emotive guidance that you're giving with regards to what has transpired in court. So thank you so much.
Thanks for having me, Yog and Gregory. It's always a pleasure to be here.
Thank you very much, sir.
Take care.
Thank you very much. And so, if you're not joining us, elections and COVID-19 was very shortened version. That's because we were bringing you live coverage there from the Court of Appeal in Kingston, where majority decision is given the court jurisdiction, as well as, and I think you might put it in a little better words than me, allow some votes to be credible, and I put all those in inverted commas. We are going to be with you this evening in room 592 to bring you a little more as to what really transpired. I think half of Guyana would be a little shell shocked at this ruling, and I think that's an understatement within itself. What does it really mean? How do we move? How does the country move forward from here? How does GCOM move from here? What are some of the options that are available? Is there likely to be a CCJ ruling? Sorry, case. So what we could conclude at the moment, we this isn't over yet by any means. We will be seeing delays as far as a swearing in of a president comes. That much could be concluded. Yoke, over to you, and maybe we could have a wrap up so we could get ourselves ready for room 592. We apologize, but it was all. The court was at the center of everything today, and we could not miss what bring you some of those very rulings that was coming there from three judges, appeals court judges, Justice Rishi Prasad, Justice Bassington Reynolds, and Justice Don Gregory Barnes. Over to you, Yog.
Thank you, Leonard. And yes, viewers and listeners, our apologies also for the horrible quality across the internet feed. It is totally outside of our control, but we apologize nevertheless. So, ladies and gentlemen, the court would have ruled or handed down its ruling earlier. As we all know, it was a 2-1 decision. Justice Rishi Prasad would have immediately thrown out the case and say the court has no jurisdiction to listen to it. However, the other two judges would have ruled that that they agree that there is jurisdiction, and in so ruling, they also decided that the meaning or the interpretation of more votes cast, the constitutional words, can only be or should be translated by looking at the order, GCOM's order, and translated to more valid votes cast. It is my personal opinion, and counsel has not disagreed. It is my personal opinion that what the court has allowed is it has allowed a subsequent law or a subsequent order, a subsidiary law, to infect the constitution, which is supposed to be the supreme law of Guyana. And so by saying that this translation goes right down back to the order of GCOM, it allows the order of GCOM to therefore sway the impact of the Constitution. However, the learned judges, I'm sure, would know and would have seen this from another angle, and we have to respect their decisions. So, Leonard, I just want to go with what you said earlier. Yes, we are looking at getting Mr. Anil Nandlal tonight in room 592. Regardless of how we look at it, ladies and gentlemen, we have to analyze today's case to see what's the implication on having a declaration. Once again, the goalpost has been shifted in Guyana. Once again, Mr. Granger continues to squat in the office of the president. I am happy to say that the Guyana Islamic Trust has come out with a strong statement calling on the president to concede. I'm also happy to say that the Arya Samaj family across Guyana, 100 members have signed a document demanding that Granger concede. And so all of those things are happening. More and more organizations are now coming out, and they are calling on Mr. Granger to concede, because remember, all of this rests with him. I mean, the truth is, ladies and gentlemen, regardless of who is saying what at this stage, they want these elections to be annulled. They're not saying they won anymore. They know they have lost these elections, and they're throwing everything into it. Leonard, we'll also have to discuss what's happening at that, but it cannot be now. But we got to look at the monies that are being thrown at that hotel, the Ocean View thing. Kaito News has carried a good article on it. Millions and millions and millions of dollars being wasted there. We got to look at the press release made by GPL on those truck purchases. We got to look at what's happening at GCOM. So certainly, ladies and gentlemen, tonight and tomorrow on Elections Watch, we'll continue to assess and analyze some of these things. Also, there's been some serious charges made by APNU AFC of some organization named Cambridge Analytica, and some of the things, contracts that governments would have entered into in procuring the services of these lobby firms. So we got more to say on it, and who has really been paying these people millions of dollars, to get what they were doing in this country.
Yes, and I do thank you for that, Yog. There are many things to be discussing today, and obviously at the top of people's minds would be the impact, the scenarios that are likely to play out from this majority decision by the Court of Appeal this morning in Kingston, this afternoon rather, at Kingston, and this evening in room 592, we're going to bring the experts on and try to break it down in layman's term so that all Guyana can have an understanding. What we know so far is that there can be no swearing in at this point in time unless GCOM decides that it has the power to do so. And there is some school of thought by some legal minds that GCOM does not have any orders stopping it from doing what it's supposed to be doing. This is handling elections, dealing with election processes. And so we will be examining a couple of those scenarios when we come back this evening with Dr. Yog Mahadeo and myself, Leonard Gildarie, in room 592 at 7:30 p.m. sharp. So we thank you for joining us here. Yog, any final words before we part company here?
No, you actually said the very, very right thing there. That is, there's no injunction. There's no injunction that would have been granted to stay or to hold GCOM's hands. It's up to the chairman to decide how she wants to go forward. I'm hoping that, we'll see a statement coming out from GCOM or from the chairman very soon.
Absolutely, and I do thank you for joining us for this special edition of Elections COVID-19 Watch. We would have been bringing you not so long ago coverage from the Court of Appeal there with that very important case, elections case, motion stopping Chief Elections Officer Keith Lowenfield from handing over a report to the GCOM chair, Justice Retired Closet Singh, so they could go ahead and have a swearing in of a new president. So we're going to be back with you at 7:30 p.m. sharp, room 592, Dr. Yog Mahadeo leading the way, and myself, Leonard Gildarie, on only in Kiteshore Radio, 99.1, 99.5. And if you've missed all of this, so you could get us on Kiteshore Radio, Facebook, YouTube, or Kiteshore News Online. And so we are going to be with you back this evening. In the meantime, do have a pleasant rest of the day.